This is a Brooklyn News special report.
This is a Brooklyn News special report. Thank you for joining us. In just moments, we expect day 4 of the preliminary hearings in the Charlie Kirk case to get underway, and we're standing by for them to begin. I'm Jackson Mitchell. It's good to be with you. We have a lot to talk about today, and what happened not only not only what is going to happen in today's proceedings, but what happened in yesterday's proceedings. So yesterday when we were on the air, there was a talk and there was a witness on the stand. Well, after that, after we had gotten off the air for Brooklyn News Live, excuse me, I'm gonna grab a drink real quick. After we had gotten off of the air, there was a discussion whether to play an interview from Lance Twiggs, who is the roommate, or was the roommate, of Tyler Robinson. So there was discussion to play this interview. The prosecution was arguing that yes, the full interview should be played. It's about 37 minutes long. In court, video and audio should be played. So then the argument continued, and the defense would argue that this would violate the Tyler Robinson's rights. This would make the release of this would make it where the jury pool would be inclined to be more biased. So now here we are today, and the judge would rule yesterday that 16 minutes of the 37 video would be redacted. So then after that, the court would adjourn for the day and say they're going to go home, edit the video. Now the video we expect has been edited, and it's going to be played in court today when they begin. The time now, 9:01 a.m. It's set to begin any moment now in that courtroom. So as soon as it does, we have that live look, and we're going to take you there. So let's just kind of recap here what we're talking about. And I apologize about my voice today. And we're going to kind of have this up for you guys, this screen up for you guys, so you can kind of see what's going to go on today, what's happening. So we expect additional witnesses today. We expect more testimony. Most importantly, though, at the beginning of this, that we're kind of waiting for is the interview with Lance Twiggs. So we know now that Lance Twiggs kind of lives in Texas, is what we've heard from our reports. As I was going to do my research yesterday, we know that he now lives in Texas instead of Utah, but he was the roommate / lover of Tyler Robinson. And we know that in this interview, he's expected to discuss Discord chats, things like that, relationship between him and Tyler Robinson. It's unclear exactly, of course, to the public what was in that 16 minutes that was redacted. So that is going to be key here. That is something that we're going to watch for, as again, we expect at any moment court to get underway here. So now we also know that there was, I do want to note that there was an official that spoke in the courtroom, or not in the courtroom, excuse me, outside the courtroom before entering, talking about conspiracy theories and saying that the worst conspiracy theory is the one that people are saying that Tyler Robinson was never on the campus of the Utah Valley University. Now, that was not my words. That's from an official that spoke before entering the courtroom a little bit earlier. So again, we're standing by for this hearing to begin. Yesterday, we saw witnesses continue to be on the stand. The prosecution pressing them. Give me one moment, you guys. So now at any moment, we expect Judge Tony Graff to come to the stand. So now prosecutors, yesterday, they had continued having DNA evidence entered into evidence, talking about DNA and forensic evidence, and what they say links this case directly to Tyler Robinson. Now, Charlie Kirk's widow, Erica Kirk, and other family members had remained in attendance. We expect them to be there today. We have not seen them in front of the cameras at all. They've kind of made kind of a entrance in the back door as they have come into the court each day. So that's going to be something to watch for. We know that multiple times in this week they have exited and re-entered. We know the judge has said that even though during like regular people essentially are only allowed, like the press, if I was to exit the courtroom, I'm only allowed to enter again during a recess or during a break essentially, but they have allowed special permission to Erica Kirk to enter and exit at whatever time she finds necessary, due to the fact that at times the nature of this case is explicit and can be kind of dark to her, as not only Erica Kirk, the widow of Charlie Kirk, in attendance, but we also know that the parents of Charlie Kirk have been in attendance. So, takeaways from yesterday: the roommate interview. That's the big one. That's the big story that we're gonna hear from today. We're gonna hear that audio today, or we expect to hear that audio today. So, video of Robinson's surrender was also shown in court yesterday, and DNA evidence continued to be challenged by the defense. Now this is a preliminary hearing. So to kind of explain this, this is a 5-day preliminary hearing where essentially it is for the judge to decide whether the prosecution has enough evidence to take this case to trial. So as you go on, there's going to be arguments about evidence. We know, of course, in a trial, this would be fully released. You know, there would be no redactions. It would all be public. But there is redactions because the prosecution, the prosecution has argued for no redactions, but I should say the defense has argued for redactions, saying that if all of this information gets out now, it might kind of infect the possible jury pool, the possible people selected to be in the jury if this case were to go to trial. So their argument has been it violates fair trial rights of Tyler Robinson, saying that it might, specifically, I mean, to go towards this interview, they said, you know, that might inflict, and in fact, his rights to a fair trial, because if this gets out widely to the public, people in Utah County might know about this. Now, I was listening to some analysis yesterday as I was also researching for today's coverage, and we heard directly, and I was listening to a defense attorney who said the prosecution is going to focus on how Robinson's beliefs differed heavily from Charlie Kirk's beliefs, specifically when we talk about religion, and it specifically noted how Utah County is, of course, a highly Mormon place, and that might inflict even more into the jury, saying that they might have kind of a bias already on religion and they may not already agree, so that could, in a way, help the prosecution here, even though, of course, you're not allowed to come into a trial with bias as a juror. So it's going to be something to watch for here out of Utah County. At any moment, we expect this hearing to get underway. We are continuing to stand by for this. Now, there has been immunity granted for Tyler Robinson's former roommate and alleged lover, essentially, Lance Twiggs. We know that he was granted immunity in all of this, and that also the prosecution trying to have him come in front of the judge in this case, trying to have him as kind of a witness come in front of the judge and testify, but the judge ruled that he didn't have to do that. That Lance Twiggs did not have to do that. So going forward in a trial, if this case were to go to a trial, just to kind of bring in a hypothetical here, Lance Twiggs would be expected to testify. That is something that we would likely see, and of course this would also again likely be in front of cameras here. So we're again waiting just 8 minutes past when it was expected to start. Unclear what's the hold up quite yet, but we know we are continuing to stand by for this hearing to begin, which again it could at any moment. Want to note also, as we're kind of standing by, we will have an edition of Brooklyn News Live coming today at 2 p.m. Central Time, so that's going to be 1 p.m. Mountain Time. So if you're looking at the clock there on the screen from the location of Provo, Utah, it's going to be 1 p.m. when we will have our edition of Brooklyn News Live. They'll likely take a break around 1 p.m., a lunch break that's around an hour long, and we will have our entire edition of Brooklyn News Live. There's a lot of news to talk about, so we're going to dive into all of it coming up on today's edition of Brooklyn News Live. And actually, behind the scenes, to let you kind of into how it works here, it's like as this hearing is going on and I'm taking my notes about the hearing, I'm also preparing for Brooklyn News Live for today. So this hearing set to begin here at any moment. I'm just going to check my notifications to see if we have any obvious reason why this might be a holdup. So give me just one moment here. I'm not seeing anything just yet as to what might be the holdup. Looks like we might be working on the feed here, the pool feed for today. One moment, you guys. I'm working on several different things here. So again, we expect this hearing to get underway. Sorry for the silence here. We expect this hearing to get underway at any moment in time. As soon as it does, we're live here, so we'll take you there live. We're just waiting for it to begin. Sorry guys, I'm just reading up on the news here to see if we have any updates as to what the delay might be. The delay might also be the court might be listening to this audio here, because we know yesterday towards the end of the hearing, the judge said, okay, if the prosecution goes home and they go to the office or whatever, they edit this out. They edit the 16 minutes that the judge ruled be redacted out. He said, send it to the defense. Then after it was sent to the defense and they both agreed, he said, go ahead and send it to the court so the court can review it. So that might be what is happening here. The court might be reviewing what is happening here. So it's going to be interesting, excuse me, to hear from this audio coming up here in just a few moments. Now, we know yesterday as well, the lawyer for widow Erica Kirk, the Kirk family, came forward actually and spoke at the hearing, wishing that the full audio, the full video audio interview with Lance Twiggs be released in its entirety. And that was the same with the lawyer for the press, because of course, the press has had to obtain a lawyer in all of this because of the fact that there had been so many arguments from the defense arguing that the press should essentially not be allowed to have a camera in the court, and then they weren't allowed to show the shackles of Tyler Robinson that he is in while he is in court. I do want to know, we do have a little bit of news here from the courtroom. We are getting, and I want to show you, this is a post from someone who has been following this case closely here, and you see there on your screen, I didn't realize it was going to pop up so quickly, but there you go. You see there on your screen this post on X from Michael Ruse, who says, new filing from Kirk family asks Judge Tony Graff Jr. to show, quote, all exhibits from this week's hearing in court. Charlie Kirk's widow Erica and his parents traveled to Provo to bear witness to the evidence and haven't been able to see it at all. Quote, the victim's family position is simple. At a minimum, every exhibit entered into evidence during the preliminary hearing must be visible to every person lawfully present in the courtroom, unquote, writes family attorney Jeff Neiman. Quote, to receive evidence in a manner shielded from those seated in the courtroom, as happened today, is not transparency. And you see a screen recording of the phone, what appears to be scrolling through that case there. We are still awaiting for things to get underway. They're live in Provo, Utah as we stand by. What's always interesting is the second that we actually go live on time, the second we go live when a hearing is expected to begin, because it has been beginning on time all week. Here we are where we are having a moment where it's not beginning on time and we're a few minutes late here. And excuse me, guys, might have heard at the beginning that my throat is a little bit sore, so I'm drinking hot tea right now, that hopefully that will help it a little bit. My voice has gotten better since the start of the broadcast, if you watched at the beginning. So just continuing to watch here. I'm scrolling through social media, see if you have any updates. Sorry, you guys. I'm really trying to figure out what might be, if there is like a direct reason that has been released as to the whole dub. Now, I understand that the people that are already inside the courtroom do not have any type of cellular device or an electronic device on them, so they're unable to tweet. So the only time we're getting like direct updates is either from people outside the courtroom or people that are watching just like I am and bringing live updates here. The camera zooming out, zooming back in. I don't know what that means. Does that mean it's about to start? Who knows? But the audio is turned up here, so the second that we get something, we'll be able to take it directly inside the courtroom as things begin there. So while we wait here, what we're actually going to do is give me one moment, you guys. While we wait here, I might show you guys some video here. One moment, you guys. I might show you guys some video here that is coming from the courtroom from yesterday. The evidence that was released that shows um Tyler Robinson saying that he was guilty and essentially turning himself in. We know that is how he was arrested, as he turned himself in. So I do want to play you guys some video here. So I might be able to pull this video in for you guys and show it to you. Give me just one moment here. Behind the scenes, you always think we're quick to get video up, and then you realize that it actually does take some time. So this is going. So give me just a moment. Sorry, guys. I'm trying to get this all pulled up for you guys. So why don't I'm going to show you this video here. I'm going to kind of zoom it in. Oh, and it looks like court might be getting underway. Okay, here's what we're going to do really quick. Oh, maybe that might be just in the camera. Let's go ahead and we're just going to show you, because I don't hear audio from the courtroom just yet, but it does appear that they're moving around just a little bit. Yeah, it just appeared somebody might have bumped into the camera or something. Okay, we're going to show you this video. This is revealed yesterday inside the courtroom, where it appeared as if Tyler Robinson kind of conceded to this case, saying he was guilty. Take a listen.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA, and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
Yeah, so you heard about the moment that he was arrested. A video played showing kind of the moment that he would say that he was guilty of this crime, and you see there. So we're waiting for court to begin still. Here at Provo, Utah. There at Provo, Utah, I should say, not here. We're in Brooklyn. So as soon as it does, of course, we have the live feed pulled up for you, and we're going to take you there. So that was the moment there that they played that video that was kind of inside what appeared, I think that was inside the police department, and then I think they might have interviewed him as well, which we know that he turned himself in. We know that they eventually, at first, if you remember, you may have heard testimony on day one that they had arrested someone soon after the shooting. That person was later released and was not the shooter. And then eventually, after, investigation, research, they were looking for Tyler Robinson, and then Tyler Robinson would turn himself in. So, there we go. So, that was the video from yesterday that was played inside the courtroom. Again, the big story today is to kind of bring you back up to date here. What we're looking at, the big story today is going to be the Lance Twiggs interview. Now, Lance Twiggs, it was the roommate and kind of lover, alleged lover is what we've heard of him being explained as when we talk about the relationship between the two, of Tyler Robinson. Now, 60 Minutes were ordered to be redacted from this interview. Were ordered to be, ordered to be redacted from this interview. And so now we're at this moment where yesterday they adjourned early, and we're told to they were going to go to their office, go home, whatever, you know what I mean, go leave the court, edit the video, redact out the 16 minutes excuse me, and bring it ready to play today. So now that's the moment that we are at right now inside this courtroom as we are waiting for this to be played. I want to full screen the courtroom here as we are continuing to stand by for things to begin there, which they could at any moment. Just realized I've now been talking for 24 minutes about this case. There's a lot to talk about for sure, and we know that on day 2 of this case there was new video released. The camera's moving. I don't know if that means anything. I will let you know I do have the audio turned up, so the second that they kind of unmute it, essentially, we will be able to take you live into the courtroom and begin listening in. You see there full screened up is the live. Look into the courtroom. So we're standing by for things to begin here. The camera moves again. It did this earlier, but then it went right back to where it was. I don't know. Maybe I'm not like a huge camera official. They might be white balancing, but usually that involves like it takes a second to do it. So gotcha. Okay. Sorry, standing by here. I'm just looking to see if we have any more information. And again, I'm scrolling on X right now, formerly Twitter, to see if there is any new information on all of this. So here's some. We actually do have some video from Fox News showing Tyler Robinson arriving at the court today. Give me one moment. I'm gonna try to pull it up for you guys. Here, if we can. Yeah, here it is. Here's the video. Okay, let me. Okay, this is from Fox News that was released, showing Tyler Robinson entering the court. Of course, he enters every day in kind of that SWAT-looking vehicle that you see there. And maybe he goes. It looks like maybe he goes underground using that back entrance that we talked about a little bit earlier there. Can't quite see Tyler Robinson, but quite the entrance. We know there is lots of security when he makes his entrances. It is quite a lot there each day when he makes his entrance, and it looks like there we go. They're trying to open that gate so that he can move forward there. So there you go. That was his entrance today inside the courtroom there from Fox News, showing that video. Again, we're just waiting for things to begin here, which they could again at any moment. Unclear what exactly the delay is. We're waiting to foresee what that delay is. And as soon as we do, okay, still not having no updates here. Sorry guys, I'm just continuing to scroll to see if we have quite literally anything. I do know that there was a report just a few moments ago that there was someone kicked out of the courtroom that was an anti-Erica Kirk protester. That was just a few moments ago, so unclear exactly what if that was the reason. That was about a tweet from about an hour ago. I'm actually going to play you guys some video here. Give me one moment. I want to play some video for you that is coming into us right now from earlier. This was not right now, I should say, from earlier. Give me one moment. We might have time to play it for you before this all begins. Give me one moment. It's going to take me just a second to set up the live feed, so hold with me here. It was a little bit earlier. It was the friend of Charlie Kirk who's been in attendance to these hearings speaking to the press. Here is those moments. Again, I'm trying to pull up the feed for you guys, so give me just a second. The friend of Charlie Kirk, Brandon Tatum, who I referred to earlier as an official to this case. I was trying to identify him here. He just spoke to the court. So again, please stand by with me here. I'm going to try to get this ready for you guys. This was moments ago. Okay, let's play the video for you as he spoke to the press.
Case is a bunch of hogwash. And I'm gonna tell you the biggest, most crazy conspiracy theory is that Tyler Robinson was never at the UVU campus. That is a flat out lie. That somehow he was coerced into turning himself in even though he wasn't involved. Let me just say this because I think it's very clear that if you don't have him named, why would he turn himself in? If he was never on campus ever, why would he voluntarily take responsibility for something he wasn't even associated with? That tells you that there's something there, and if he didn't get arrested until his parents were interviewed, that tells you there's something that they said.
Okay, I'm going to interrupt here because it appears Judge Choningraph has just took the stand. Let's take you there now and turn the audio up and listen in here. It does not appear that he has began his remarks just yet, but is looking at the computer screen and has entered the room. Looks like the audio has just been unmuted. Let's listen into the court here.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunender, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Ms. Erica Kirk. Good morning, Ms. Kirk. All right, as you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer, and I invite you to do the same. Every person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense. All right. As we begin this morning, I wish to, I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we've came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so, and I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process, and I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media believes, the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. We're maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we of course support that.
Thank you. All right.
Your Honor, the state would like to be heard on the briefing, briefly.
For?
The briefing that was submitted last night.
All right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery, and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that correct?
I do, and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record,
Okay.
and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
think, Your Honor, and then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus, the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is what I'm going to next. Mr. Ballard?
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here, and this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page, based on what the court just said.
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach. When Your Honor made his ruling yesterday afternoon. It wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence. And I would like to be able to point the court to those. We've got two brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript?
I do.
In front of you? Okay. First of all, at the very, very bottom of page 10, beginning with the words, "was he," and then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see, right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until
16, the timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the fifth paragraph down, Mr. McBride stating "okay," and then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you.
Have you heard?
Yes, you may.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked.
Alrighty, so you continue listening in live right now as the court has just ordered additional redactions to the interview with the former roommate of Tyler Robinson, Lance Twigg. So as we continue to listen in, I want to note here, as we're able to break in at any moment and kind of bring you analysis, the prosecution has just said that essentially some of the redactions that the judge ordered yesterday may have been essentially this kind of not reasonable is essentially what they're saying, that they don't understand the exact reasoning behind some of the redactions ordered by Judge Tony Graff Jr. here. So after the judge ruled further redactions, now they are saying that some points that were ordered yesterday still remain unclear. And now you are hearing the argument between that. Now, before all of this, you also heard the judge ruling on a filing that came late yesterday after court had adjourned from the Kirk family lawyers, the lawyers that represent the widow of Charlie Kirk and the parents of Charlie Kirk, the family of Charlie Kirk, I should say, not ordering, I should say, but rather arguing that all evidence should be released to the public. The judge said that he would not release and order a blanket ruling on each exhibit, and essentially that it'd be decided on an exhibit by exhibit basis, and that the court will balance both the Kirk family and Tyler Robinson's rights to a fair trial. Let's take it back live into the courtroom and continue listening again. I just wanted to break in for just a moment as we kind of had a moment as we were listening into some of those arguments. Let's continue listening into the court.
Outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him, and then also it's very relevant to the enhancement that we have charged.
All right. Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 15:39 on the video, starting with "was he," and ending at 16:46 with the last word "asking." After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. Right after 3255, where
All right.
Mr. McBride states, okay.
I see. Thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with OK, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with OK, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note the, and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340, I'm sorry, up to 3340 may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well, that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case. And what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence, and Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then they immediately, it was the police that immediately released that recording to the press, who then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate. Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value, and even if it did, the circumstances are completely different than from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
at this time. Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, a Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that Exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. Not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public, and the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on. And that is even more important to the victim representative's right to be able to be present and to observe these proceedings. Thank you.
All right, counsel.
Your Honor, if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like the transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleave below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stressed what we did yesterday, that much of, as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that that middle step is a meaningful one. And if the court were to decide that that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you are viewing. They want to see the evidence. And we understand you have to balance. But at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request, 16 point, well, so under the three factors, or the three levels, admission to the court, publication to the gallery, and then publication beyond the gallery, what is the request for each of these exhibits?
We are asking, Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit, but again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Thank you. Just the court just wants to. And just for clarification, 16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings? And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing, and it's a factor. So I want to make sure that that issue has been presented by the parties if you choose to.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears not in the information? Again, I'm just trying to create a record of what is out there from your perspective, so the court can consider that in its analysis. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
Your Honor, State's Exhibit 16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything further from any party? To defense?
No, thank you.
To the prosecution?
No, Your Honor, thank you.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication within the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing, and I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on the state's request to publish Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rizzo and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rizzo because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rizzo, Estes, and Skilling. Unlike the broadcast interrogation in Rizzo, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish Exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court. Counsel, how would we like to proceed?
Your Honor, just to clarify the record, the state has redacted that portion. We anticipated that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right. I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at 10:50. Court is in a brief recess.
Alrighty, their court is in a brief recess. You hear that there. This comes after a ruling from Judge Shoney Graff that even though the defense argued that some of the evidence delivered prejudice to Tyler Robinson, it may still be released. A quick break. Our coverage continues in a moment. Alrighty, welcome back here into this Brooklyn News Special Report as we continue our coverage of the preliminary hearings with accused Charlie Kirk assassin Tyler Robinson. Right now, I'm Jackson Mitchell. Welcome back, and we snuck in a quick break there, as right now we are continuing a 15-minute break the court is taking. They will return at 11:50 Central Time, so 10:50 there. So in just about 10 minutes, just to wrap up the day as it comes, and we are providing you guys with live updates there on the far left side of your screen. So the second there is an update, we're updating it and bringing you updates to this case as they come in. So this morning we started out with a response to a late night filing by the attorney for the family of Charlie Kirk, including the widow of Charlie Kirk, Eric Kirk, a filing that was calling for evidence to be released to the public. Judge Tony Graff Jr. making a ruling on that this morning, saying that there will be no blanket ruling on all evidence and that the court will balance both the Kirk family's rights and Tyler Robinson's rights to a fair trial. So that was a ruling made again this morning. After that, then there was a continued argument on redactions to Lance Twiggs' interview that law enforcement did. Now, Lance Twiggs is the former roommate and alleged lover of Tyler Robinson. Those redactions, further redactions were ordered by the judge, and then there was an argument from the prosecution that, well, some of the redactions that the judge had ordered yesterday evening didn't make sense and were unreasonable. Now, the judge, in response to that, Graff said the issue is on publication, not relevant, and ordered that some things that the prosecution said could be released, but then the other side of it, that some of that could remain redacted. And then again, saying that those redactions are based on publication and not the relevance of what was being said there. And then we have heard continued argument really throughout these entire last, I would say, this is day 4, so now 3 days of hearings, the argument of whether evidence should be released to the public. And the argument here from the defense has been that it brings in prejudice to the case, and that it allows for Tyler Robinson, if this case were to go to trial, not to have a fair trial. So, and the judge has had to take that into consideration, and has had taken consideration that whether this should be played in the court where the people can see it. And that is something that both the press lawyer and the Kirk family lawyer has argued, that even if it's not revealed in front of cameras, they say it is a step forward, at least, to allow it to be seen to the family of Erica Kirk, to the family of Charlie Kirk, the parents of Charlie Kirk who are inside the courtroom today. And saying that it should be at least allowed for them to see, saying that they have had a lot of pain and that this is hard to watch in the first place. So again, when we come back from this break in about 8 minutes or so, we are expected to hear from the prosecution the video showing Lance Twiggs' interview, a never before seen video, and it is going to reveal again. They are going to reveal again this video, this interview with Lance Twiggs, that we are going to watch live here as soon as it is revealed. A live look in the courtroom right now, full screen for you, as we continue to follow the preliminary hearings. A 15-minute break. Not much to see there, but we are going to sneak in another quick break as we continue to follow what is a busy day out of Provo, Utah, as preliminary hearings continue. You're watching a Brooklyn News Special Report. Okay, welcome back into our coverage here. Court again taking a 15-minute break. Got about 4 minutes left in this break as we were just before the break recapping what has occurred this morning in this case. Major arguments from both the prosecution and defense, specifically on whether evidence should be released to the public, whether evidence should be released inside the courtroom in a closed hearing or in front of the cameras. Now, we know when we return from this break, the moment that many have been anticipating, this interview with Lance Twiggs to be played by the prosecution. Now, late yesterday, the judge ordered nearly 16 minutes of the 37-minute video be redacted. Then this morning, there was further argument on redactions, the judge ordering further redactions. Not only that, then the prosecution would argue that some of those redactions were unnecessary. The judge siding with them on a few of those and then keeping his previous order on the others, saying that this is based on publication and not relevant. That was the specific words there from there as we are continuing to stand by for this 15-minute break to wrap up. Again, if you've been watching here, we've kind of been evolving here with how we're covering this case. So if you look there on the far left side of your screen, I know I'm on the far right now, but if you look on the far left, you'll see the live updates there. We're providing live updates. The moment that something happens inside this courtroom, we have got live updates for you. Again, the court, just before we left you, ruling against the defense, allowing some evidence to be released without creating prejudice, saying that even though that is the argument from the defense, the judge said that, well, some of this evidence that you are arguing should not be released, doesn't create prejudice, doesn't affect Tyler Robinson's right to a fair trial. Of course, these are the preliminary hearings. So these hearings are to decide whether this case could go to trial, whether the prosecution has enough evidence to take this case to trial. Now, yesterday, there were major arguments towards the end of the day on this interview, how it would be played, when it should be played, how much of it should be played. And then the judge would make a ruling on that late yesterday after taking quite a lengthy break and then reviewing the transcript. I believe it was a 19-page transcript from this Lance Twiggs interview and revealing more about it and ordering some of those redactions. There were also more witnesses on the stands talking about what directly connected Tyler Robinson to the scene, to Utah Valley University, what directly connected him to being there. Now, we also learned throughout these preliminary hearings that Tyler Robinson was actually, he spoke to law enforcement after while on the Utah Valley University campus, and he also spoke to a Turning Point USA official. Of course, Turning Point USA is what the company that Charlie Kirk founded, and you heard him, the prosecution and evidence, I should say a witness, the prosecution press and evidence saying that he had direct connection to a Turning Point a connection with a Turning Point USA official and spoke to them while he was at Utah University. Now that conversation occurred before the shooting, and we would later, video would show what the prosecution says is Tyler Robinson on top of a Utah Valley University building, and then the shooting would occur. He got off of the building, runs away, and that is, again, what we have learned throughout all of this. So very, very interesting. The time is now 10:50. The judge could come back to his seat at any moment now. Again, they took a little bit of a break here to work on some of those redactions that were needed within this video. So they could play it out to the court. So that is what we're waiting on right now. The judge could come back to the stand here at any moment, come back to sit down. So we have the audio turned all the way up here. We're waiting for it to begin. Again, a 15-minute break was ordered here for further redactions inside to be kind of placed in this video. We also learned through today that some of the defense had actually noted that there were audio redactions, but yet the video still played, is kind of how they explained it. It was unclear kind of what was happening there, but the defense noted it to the prosecution. The prosecution changed it and then released kind of a version 2 and sent that over to the court, and that is what is expected to be played. I guess it would now be like a version 3, since there were further redactions ordered here. So it might be just a few moments. It looks like the camera's jiggling. Maybe people are walking back inside the courtroom now. So we are just awaiting for the hearing to get back underway here. But again, right before we left you, it appears the judge has just taken the stand once again. Let's listen in.
We'll wait a moment for the public to be able to come back into the courtroom.
Okay, just for a quick moment here, the audio come up. We'll wait for a moment for the public to be allowed back into the courtroom, but the judge there is sitting on the stand, and we are awaiting for things to get back underway once again. So we're watching it live here, and we're going to bring you updates as we get them. So again, as soon as the judge comes back, we'll take you there live. You one moment. So you guys are working on some things behind the scenes quickly here. Here's what we're actually I'm gonna take you back full. One moment, you guys. Sorry, this is behind the scenes stuff we're trying to work on really quickly here. I'm gonna take you here for just a second because I do want to work on this live feed really quickly and make sure we are getting the best quality of the live feed. Okay, looks like we are. Gotcha. Okay, so again, standing by for things to begin there as we are continuing to wait. The judge saying waiting for the public to be allowed back into the courtroom, but we know that he is on the stand below. The audio was muted once again. We're waiting for it to be unmuted again. As soon as it does, we'll take you there. Before we left you, the court had ruled against the defense here, allowing some of that evidence to continue to be allowed to be publicized, saying that it does not create prejudice, does not violate Tyler Robinson's right to a fair trial. So that is kind of what we saw there. Since these preliminary hearings have begun, we've also have seen new video, that never before seen video, from Utah Valley University cameras that show what the prosecution alleges is Tyler Robinson on the campus in a parking garage, entering and exiting, eating Chick-fil-A for lunch, then coming back after that, attending the event, and that is where the alleged shooting would have occurred. So now we are here, and that I believe that was day 1. I believe that was day 1 that we saw that video revealed. Now we're on day 4, and here we are. It might have been day 2 that video was revealed. I can't quite remember. Now we are on day 4, and here we are now with video from Lance Twigg. So again, this is not the trial. This is kind of on the way to a trial, you could say. So this is 5 days of preliminary hearings where essentially the prosecution has to prove that they have enough evidence to take this case to a trial. And as you're watching us live here, we're going to sneak in another quick break really quickly here. We have got more coming up on the other side. Again, at any moment now, the court could resume, and we know that the judge, Tony Graff Jr., he's now back on the stand, but he said he's going to wait a moment for the public to be allowed back in. So as soon as that happens, you got the live look right there. We're going to take you there live. Throughout the breaks here, we're going to change things up here. So we're going to have kind of like the thumbnail, and then we're going to have the live update sticking with you here. A quick break. Brooklyn News Live returns in just a moment.
Session. Welcome back, Tony.
Okay, welcome back. Court appears to be back in session after that break. Let's take you live there and begin listening in.
Just as long as it takes to show the video, so maybe 10 minutes.
All right. Well, we'll go into, well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize that we were at this point. We'll be in recess for 10 more minutes. So by 11:05 approximately.
That should work, and also we can inform the bailiff as soon as we're done if it's ahead of that time.
All right. So ladies and gentlemen, I apologize. I thought we were ready to proceed. I want to be respectful of all time, everyone's time, but all at the same time keep this hearing moving forward. So court is in a brief recess.
Okay, court in a brief recess once again. I actually want to take you back to the moment that I want to take you back to the court from just moments ago here. So give me just a second, because we didn't quite get to hear what was said here. So I want to see if the camera happened to catch it. So give me 1 second. I'm rewinding back the as they would say in the old days, the tapes, but we're not doing that. We're just winding back the live feed really quickly here to see what they said just a few moments ago. Let's listen in here.
Back in
Again, just
session.
moments ago. So
Welcome back. Turning to the state.
I apologize, Judge. We were having computer technology issues, and we believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right. Well, how much time do you need?
Just as long as it takes to show the video, so maybe 10 minutes.
All right. Well, we'll go into, well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize that we were at this point. We'll be in recess for 10 more minutes. So by 11:05 approximately.
okay, this is the portion that we had seen. So sorry, I just wanted to wind the cameras back here because I happened to miss what the reason was. I believe that's what it was. I thought they just said they needed more time to work on the video here. It looks like they need more time to play the video back just to make sure that they got the redactions all correct. So now we're waiting another about 6 minutes or so here. 12:05 Central is when they are going to have this. Probably about 1 p.m. is when they're going to have a lunch, and then at 2 p.m. they should come back. That's how it's been working day by day here. We'll see how things go. We're going to continue watching it here live here on this Brooklyn News Special Report. Again, we've been doing this day after day after day, bringing you live coverage of it. I know yesterday they had a later start, so we were brought you the hearing over on Brooklyn News Live. So that's likely what we're going to do again today, especially if things line up how they're supposed to line up. At 1 p.m. they take this lunch. So again, I just wanted to wind the cameras back really quickly there and begin listening into that again. So we're going to take another quick break, you guys. There's only so much I can say about this case, and I think I have said a lot. I think I've said a lot about how it's going to work, what is this case about, what has happened today. My notes aren't that long today. I won't reveal too much of them, but they're not that long today. Yet, of course, we're in the very early stages of this. I'm ready for the video to take notes about the video, so I'm ready for that. But we're going to sneak in another really quick break here, probably about 2 minutes or so, and we'll come back on the other side with more recapping today. Not only that, but we'll have more on all of this. We'll be right back. This has been a Brooklyn News Special Report. We're back here in just a few moments. Okay, and welcome back into this Brooklyn News Special Report. We're going to continue our coverage here. Day 4 of the accused Charlie Kirk assassin Tyler Robinson appearing for these preliminary hearings. The hearings to determine where the judge will determine whether the prosecution has enough evidence to bring this case to trial. Jackson Mitchell is still going to be with you here as we continue our coverage. It is Thursday, July 9th. Time now is 12:04. The court took a 10-minute break, and they were expected to return in about 1 minute. We'll see if they do that as we continue to follow this trial very closely. This morning, we've already seen several arguments and several rulings specifically on the publication of things, specifically on whether the press can, what the press can see, what the cameras inside this courtroom. The Kirk lawyers are arguing that even if it was not the cameras, but the people inside the courtroom, including the press, could see what was going on, and then you, of course, explain it back to people like us here. It would be a major step in some of this. The defense arguing against that, saying that they disagree and that some of this creates prejudice to the fair trial rights that Tyler Robinson holds. The judge ruling against them, saying that, well, no, that's not the truth, and that they can't they are still going to allow some evidence into all of this. And now it is 12:05. We're standing by for things to get back underway. They said computer troubles was the reason for the second break here. So now we are seeing that they needed 10 minutes to play back the corrected video. So now that is what we are waiting on right now. Could begin again at any moment. We're standing by for it. When it does, we've got everything pulled up, so we're going to be able to take you there live. You see there on your screen how we have everything pulled up and ready to go. So as soon as things get back underway there in Provo, Utah, we're ready to go, and we will bring you our live coverage here. So many arguments already had this morning from all the lawyers. There are tons of lawyers involved in all of this, because not only do you have the defense and the prosecution, you have Kirk family lawyer, and then you also have a media lawyer. So that's four teams inside this courtroom ready to argue at any moment. And at times you'll see all four of the teams essentially will have to come into the stand and come speak to the judge and argue some of these things that they believe. And the media and the Kirk lawyer, they specifically agree on the publication of things, saying that, everything should be publicized. While the defense is against that, the prosecution says a lot of it should be publicized. So now we are watching it all here, and we're going to bring you updates when we get them live from the courtroom. So you might have noticed today we've been kind of keeping updates, but it's more of and I'll kind of pull this up for you. It's more of a context type of thing. And today we're kind of launching something a little bit new, where in this box where my face just went away, live update. So the second there is a major update inside this courtroom, we are putting it into that box right there, and we are updating it and bringing it up to you. So not only is it context, but it's telling you, putting it more into perspective as to what is happening inside the courtroom. So again, as we continue to cover these preliminary hearings in the case on Charlie Kirk's assassination. So the court again taking a 10-minute break. It was expected to come back about 2 minutes ago. The camera shaking just a little bit. It always shakes, but I never know which time is going to shake, and it's going to come back to live coverage of the courtroom. We want to note that we'll be here tomorrow for live coverage of the hearings. Once again, tomorrow, 9 a.m., depending on when things begin. I know that they have been, I know that each day they have been kind of, I know yesterday they didn't have a morning court, and then today they're going to have it all day. We'll see. I'll have to watch for the ending to see what they have here, but we'll be here again tomorrow for coverage of all of this. So you guys will have to join us then at 9 a.m. if that is when they decide to have court. We'll be here live for it, and then I will let you know, actually, tomorrow I believe they are having morning court, because they're only going to have morning court, and then at lunch that will be the end of the day. We'll see if that it remains true. That is kind of how the plan said. But as a person watching this, we've seen how slow these things have gone today, how slow the arguments have gone. We were expected to see this video first thing, and there have been so many arguments about what to show in the video, how the video, everything about this Lance Twiggs interview, that we have continued to see delay after delay after delay to things we've seen. So now we have taken 2 breaks already this morning, and we are awaiting to see this video. Still, time now though is 12:08 here in Brooklyn, meaning it's 11:08 there over in Provo, Utah, as we continue to stand by for the proceedings to resume. We're going to sneak in another quick break, though, as you continue to watch us live here on this Brooklyn News special report. Another quick break. We've got more coverage when we come back. Okay, welcome back here into Brooklyn News Live. Day 4, the preliminary hearings getting back underway out of Provo, Utah. Let's take you there live and begin listening in.
have reviewed Exhibit 16 with defense, and it comports with the court's order. At this point, we would like to put Agent Davis back on the stand and continue with displaying that, publishing that.
All right, Agent Davis, if you'd like to come forward, I remind you you're still under oath. If you'd like to have a seat, there should be a water bottle to your left. And after you're situated, if you wouldn't mind adjusting that microphone and bringing it close to you so the record can pick up your testimony. Ms. Hunt, your witness.
And just for the record and the court's benefit, we have made the edits that the court has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected very clearly. So there are sometimes large gaps of just black, empty, silent space. When there are large gaps, we will fast forward. Some of those are short enough that we'll just let it play, if the court is okay with that, with proceeding that way.
Thank you. I appreciate giving a heads up so all parties know what's going on. Thank you, Ms. Hunt.
So at this time, we would move to publish on the monitors State's Exhibit 16.
All right, and to the media, there is a monitor for your benefit right there next to you. For the camera, there is one for that direction as well as for the gallery.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. Understand that? Mm-hmm. Okay, so in order to do that, I need to place you under oath and also give you an admonition about false statements, okay? First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. You understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that? Mm-hmm. Okay. First, we're going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Well, yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
And will you describe your relationship with Tyler when you first met him anyway?
When I first met him, I didn't know him super well. He was just a new roommate, so I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on, your microphone? Okay. I'm going to repeat those admonitions just to make sure we got it recorded. Okay, so again, I placed you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on. They're saying that it's echoing, so
I think this one's mic is on.
Okay, sorry.
Okay, you're not on my mic.
That's fine.
Okay.
Okay, so we should be good. All right. Is that mic off?
Yes.
Okay, great. All right, okay, sorry about that interruption. All right, so you said when you first met you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates, is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived when on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher like ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was his typical work day like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on like where the job was and how long it was for the day. And then on certain days of the week during school, like semesters, he would then later in the day, I think around 5 or 6, go to school. Okay. So, yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Into September 10th. Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna have him spit out his gum just to make sure that
I can do that.
You mind? Tissue right in front of your laptop.
Oh, here you go.
Thank you. Thank you.
All right, so what time did you get up on September 10th?
Probably like 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.?
Yeah.
What about, he asks you here, remember how I was engraving bullets? Was he engraving bullets before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where our Dremel was and told him to make sure he doesn't set off a bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember because he'd been talking about the hunting/camping trip for a couple months, but I don't remember when he was specifically asking to engrave the bullets. So
So are we talking like a year before?
Oh, no, not that long. It would have been, I'd say at most a month before this was when he was asking.
Okay. Okay. Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
Right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And now I want to go to what's been titled 16.2. And do you recognize this series of messages here?
Yeah, that was the server of his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And who are members of this server? I don't want names, just generally. Who are these people? Members of
this is his friend group. They played D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look at it. Or go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
Yes.
Yeah, DM means Dungeon Master. So these are most of them are names they're using in the game they're playing currently.
Got it. Yeah, it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because at least I think so, because I don't think on the 10th that he messaged anyone before me at 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
Okay. So again, we're just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
To my knowledge, yes.
And that was sent, looks like between September 10th and September 12th. Looks like the last day on this is September 12th. Screen?
Yes.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting?
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home, and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home?
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it. And then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay. Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat,
Okay.
but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Okay, I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This is like him.
Yeah, his friends. Yeah, I don't know if I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
We played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some like shooting games together, but I didn't know him very well, so that was just when we had like a whole friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
Okay, so before that you have been?
For a short time, yes.
Okay. And I understand you're going by Luna at some point?
To some people, yeah, but not as an overall thing.
Okay. Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything. The Dremel that you talked about, you said he had asked for that, is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
And so did you have a Dremel then?
Yeah.
Okay.
It was in our, our apartment, we had a section where we kept all our, random tools for household stuff in our, lower basement level pantry. So, yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was, yeah.
Okay, I'm going to go ahead and end the recording for the 1102 purposes.
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from the court-ordered redactions, Did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Yeah, sorry. These are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview, he refers to the large crack in the upper left screen. So he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
is States Exhibit 16.1 a fair and accurate representation of the text thread between, or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit States Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court, of course, is very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of States Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m., will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize, let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
If we could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
If we could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
This is while they were spot, but I don't want to chance it while they were parked there. If they'd found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4, so just scroll down 1, please, Kimberly. And if you could read starting, sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. Will.
Sorry, now we're on page 6. Continue reading.
We'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud. Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if I had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8. And if you could start at the top.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
And let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15. And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly. We mentioned a Cellbrite extraction of Mr. Twiggs' phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th make sense, or you're saying September 11th?
So September 11th was when he turned himself in. It would have been September 11th, yeah.
Okay, thank you.
Yep. Yep.
All right, I'm going to show just for the witness, State's Exhibit 16.2. Let me know when you see that.
Okay, I see it.
Do you recognize this?
I do, yep.
What is it?
This is just more photos of Lance's phone. And
How
these
do you-
are, these are sorry, how to bring, sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
And what is it of?
These are the Discord messages of, that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit, 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He identifies that in his first interview with the two FBI agents, and then he again confirms that in his second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in State's Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak.
Thank you, Your Honor. We've already lodged all of our objections on all three phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
Alrighty, just to interrupt here, so essentially what you're watching right now is it is muted because there is going to be evidence that is going to be played, yet the cameras have been muted because essentially they cannot show the evidence here. So that is what you are watching right now, and that is why the microphones have been muted. We'll just stand by for just a moment here as they continue to mute the audio. We have a lot to talk about on the other side when they have the next break here. There's so much that has just happened, so let's kind of just continue listening in here. I know it's silence, but we should unmute here in just a few moments as Agent Brian Davis continues his testimony. So again, we're standing by for that audio to come back to us.
I see it.
Do you recognize this?
I do.
What is this?
This is a handwritten note or letter from Tyler to Lance.
How do you know that?
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twiggs gets a text from Mr. Robinson around 11 p.m. on September 10th telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard.
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned, I just want to make sure the record's clear. You mentioned Celebrite a few times. What is Celebrite?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data, to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. That's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Cellbrite phone extractions. Have you spoken to the law enforcement officers that performed the Cellbrite extraction on Mr. Twig's phone in this case?
I don't believe I specifically talked to those individuals, the RCFL, that did that. But they, yeah, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I've spoken to, I have spoken with the SIAC analyst who in particular found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twiggs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3, correct?
Correct.
Is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
Alrighty, so here we go again. This is something we're likely going to see several times, is when the audio becomes muted and then evidence is revealed. We heard there, you are seeing there on the right side of your screen text messages. Those messages are screen grabs from the live feed that were just released a few moments ago between both Tyler Robinson and Lance Twiggs. Of course, the major news of today that the interview had been released a few moments ago. That interview that was released again a few moments ago. Quite damning and starking. So we will talk about it. Of course, whenever they decide to take their lunch break, we will talk about it. So please stick with us here as you watch Brooklyn News Live. We got a lot to talk about on Brooklyn News Live coming up today at 2 p.m. But again, those text messages that were just revealed there on the right side of your screen. They're going to continue scrolling there as they continue to talk about different messages and videos that's being played in court. We're waiting for the audio to come back on, and when it does, we are live there, and the audio is turned all the way up right now, so it may begin at any moment. Let's continue waiting for the audio to turn back on.
I do.
What is it?
These are the images that the FBI released to the public. It would have been on September 11th when those were released. And this was, those were those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does State's Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections, thank you.
All right, noting the standing objection by defense, overruling that objection, State's Exhibit 16.4 is admitted into evidence and may be published in the courtroom.
And again, in the Discord,
As it relates to 5.1, the court previously, the day that I did it, I believe it was day 2, perhaps,
That sounds correct.
the court provisionally admitted it, contingent on additional foundation being laid, whether through testimony or through evidence. And the court notes that such foundation and testimony has been laid in order for the foundation to be laid for 5.1 to be admitted into evidence for full consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense that this is going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression, and that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant, how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and it's not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Thank you. Yes, we do. And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you. All right, I believe that should be sufficient. And Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twiggs. Kimberly, if you could turn to page 17. And because this has already been admitted and, court, correct me if I'm wrong, published not only to the gallery but to cameras at large, I'd ask that it be displayed in that fashion again.
All right. Any input from any other party on that request?
No.
All right, thank you. It may be published, and the media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with "if any," if you could read that out loud.
Okay. This is Tyler. He says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there.
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail.
Yes.
And that you were the booking officer.
That's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's an individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel?
No objection.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness, thank you. And I don't know if now would be a good time for lunch.
All right. We'll go ahead and break right now for lunch for 1 hour, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up with defense for a cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Not the state.
I have no cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination. May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next witness. Court is now in recess.
Alrighty, court now in recess there for about an hour for a lunch break. Day 4 of the preliminary hearings wrapping up here for lunch break. Want to note here as you're watching us live that you can join us here in just a few moments as we're about to wrap up our coverage. You can join us for Brooklyn News Live coming up here at 2 p.m. So they have just wrapped up for their lunch break as prosecutors continue to present evidence. We're going to bring you more on that coming up here today on Brooklyn News Live. Want to note here, I understand we're kind of going to wrap up and we're not going to have a lot of analysis like we usually do in these breaks. But as you're watching, what we're going to do, we're just going to wrap up here now and then join us here for Brooklyn News Live coming up at 2 p.m. So in about 35 minutes, 35 minutes. You can join us for Brooklyn News Live. We will have the wrap up of not only this court hearing, because we're going to talk a lot about it, because we also know that it is going to begin. It looks like we've just lost that camera. We know that this court hearing is going to begin while we're still on the air. So they said for about until 1:30 Mountain Time, so 2:30 Central. We'll be here until 2:30 on Brooklyn News Live, bringing you a recap of what has happened this morning in this hearing, and then we will bring you updates on what you need to know on the other big headlines that are breaking this afternoon. So, of course, as some of you I noted earlier, as I'm watching this and I'm taking notes on this, we're also preparing for our Brooklyn News Live coming up at 2 p.m. Join us then. In the meantime, that will conclude this Brooklyn News Special Report. Again, our coverage is going to continue of this court hearing going when it begins at about 2:30, or is expected to pick back up at about 2:30 until 3 p.m. So join us then. In the meantime, again, that concludes this Brooklyn News Special Report. You can follow us on all of our social media pages there at the bottom of your screen. And for all the news you need and more, you can visit brooklynnews.com. In case you're planning on missing the coverage coming up at Brooklyn News Live at 2 p.m. You can watch, if you go to the Associated Press's YouTube channel, you can watch the hearing. And then also, we will start back up with coverage tomorrow at 10 a.m. for the last day of this all. Unclear if we're expected to get a ruling tomorrow on whether the prosecution has presented enough evidence to take this to trial, but we'll see. Thank you for watching, you guys. We're back at 2 p.m. Join us then.